So we can go ahead and hop into this. I'll go ahead and pass the metaphorical mic over to Karalynn and we can get started.
Hey, good morning, guys. Thank you so much for being here. Just a brief second before we jump into this. I've been a construction litigator for the last 17 years, and even before that, I grew up in the construction industry. And then in my last year of law school, my husband and I started a material supply business in the construction industry. So I really, what it feels like to work in a family business and try to keep the doors open and the fights that you fight every day. And then, I got involved in commercial construction as a litigator and really got to dive into that and some of the horrible things that are in subcontracts. And I wrote a book called Quit Getting Screwed that's got all the things that are, all the big things that are in a subcontract that you should watch out for, some of which we're going over today in this presentation. The main thing about subcontracts is that there's no set of rules protecting you, and whatever you sign will be used against you. And so we're going to kind of go through some of the more dangerous provisions today, and through the rest of this series. So feel free to put any of your questions in the chat. There's a lot of stuff to go over here. If you want a deeper dive into this material, you can buy the book Quit Getting Screwed on Amazon, or I also have the subcontractorinstitute.com. And Chelsea, if you can put that website in the chat, please. It's a free educational platform where I teach the 20 chapters of the book, and there's like 80 free forms, including a bid form, a change order form, all of those things that are available there. So check that out. Like I said, it's all free. There are some paid portions of it, but the education part is free. All right, with that being said, let's go ahead and dive into, we start with subcontractor bonds today. Chelsea, if you can bring up that first slide. Okay, what is a subcontractor bond? All right, so the first thing to understand is that a bond is not insurance. So, you go to an insurance company to get a bond, but they're not selling you insurance. So if a claim is filed on your bond, and the insurance company pays, you're expected to pay them back everything that they paid out. So it's very important that we know if we're required to get a bond that we don't ever want it to pay a claim, that it's not insurance, it's not something we can just walk away from. So know that up front, it's not insurance. So next slide. So what a bond does is guarantees your work to the general contractor or the owner, whoever. In this case, we're talking about subcontractor bonds. So you're providing a bond to the general contractor, generally in the amount of the contract, saying that I will finish my work and I will pay all my people. And if I don't, then you can file my bond to be made whole. Meaning, like, if I walk the job as a subcontractor and I have a bond, the GC can file on that bond for the cost to finish my work, right? So if you've ever had to sign paperwork for a bond, you know that you sign personal guarantees, pledge your personal assets to be able to get it. So what it basically becomes is a personal guarantee of your performance of a subcontract. And so the important thing is to look in your subcontract to see if a bond is required. A bond is normally required on all public projects, also on some larger private projects, but definitely on public projects. So if you're thinking about getting into the bond world, just know that what it is, and that it's basically a personal guarantee. So, but there are some ways to protect. First, we'll get into the two different types of bonds. So we just talk about bonds generally, but there are two different types, and normally you're required to get both. You're going to get one. So one is a performance bond, and the other one is a payment bond, right? So the performance bond will pay for the completion of your scope of work if you don't complete, right? If you're terminated and you don't finish, then the general contractor can file on your bond for the amount. And sometimes the insurance company will come in and do the work. Sometimes they'll just write a check. It all depends on what the insurance company normally does. So that's what the performance bond is. Now, the payment bond says that I will pay everybody that I owe money to, whether that's subcontractors or material suppliers. So like if somebody, a material supplier isn't paid and they send notice to a general contractor on a project, like a notice of intent to lien, the GC can turn that notice over to the payment bond and request payment from your bond if you don't pay your material supplier or your subcontractor. So we talk about bonds generally, but there are two different kinds and they have different jobs, right? So those are the two differences. All right, so some ways to protect your company if you're required to get a bond. And there's some language in the handout which was included with this, and I think I don't know if you can put the link to it, Chelsea, to make sure everybody's got it. Is put some language in your contract that says if there's a bond claim, if there's a claim on your bond made, that you get a chance to dispute it and or review it before the bond company just pays it out, because the bond company can have that option, right? A claim is filed and they just pay it even though you dispute it, right? And then you're in a world of hurt, because then you got to pay the surety back, the bond company back, and they didn't even, you didn't approve of that claim being paid. So make sure we write in the contract, if we're required to get a bond, that we get a right to, if a claim is made, we get a right to dispute it. Another thing to watch out for is don't get a bond in the middle of a project, or if you have to, because some contracts are written that a bond can be required at any time. If you do get a bond in the middle of a project, which I don't recommend, but if you have to, get it for the amount that's left on the contract, not for the full amount, because you've already done that work up to that point. So another way to protect your company is to get a copy of the general contractor's bond. Normally, if a general contractor is requiring a subcontractor to get a bond, they have a bond themselves and are required to get bonds from subcontractors. So they most likely have a bond as well. So like in that situation I was talking about before, if the GC gets a notice from material supplier that you haven't been paid, they can file on your bond. But what if you couldn't pay your material supplier because you haven't been paid? That gives you the right, once you have the GC's bond, you could file on that bond for non-payment of your material amount. So it's some protection in a situation where you could be wide open on just having your bonds and not having a copy of the general contractor's bond. So I've seen some very extreme stories on bonds. This is one of them. So a rather large general contractor was taking bids. I think it was for a hospital project. It was a huge project, and my client was the AC contractor, and he did I'm going to do all the AC work for $200,000, and the contract required him to get a bond. So he had a bond, and his bid was accepted. Well, his bid was accepted knowing that he had missed like $100,000 worth of work. And my guy was like excited. This is his first commercial project. And, he gets going and it becomes very clear, halfway through the project that he's missed something. And so now he's on the hook to do the work for the $200,000, and he's $100,000 short. And he goes and talks to the GC, and of course they're not going to give him any more money because he agreed to do that scope of work for that price. So he gets terminated, and then they file on his bond to complete the work, and he's got no defenses. The bond company pays out, and he's got to file bankruptcy, and the company no longer exists. So I say that I've only seen the bad side of bonds. A good bond is one that's never filed on, right? So, but they can be very dangerous. So just make sure that we know what we're doing when we get into those. Another way that we can personally guarantee a project is by signing a personal guarantee as part of the subcontract. So what is a personal guarantee? And normally what you'll see is at the last page of the contract, the subcontract, there's 3 signature blocks. One for the general contractor, one for you, the company, the subcontractor, and one that says guarantor. And so that third block is for you to sign in your individual capacity, not just as the company. You shouldn't have to sign a personal guarantee for a subcontract. And so what I call that is when somebody sends over a subcontract with a personal guarantee, I call it sucker fishing, because if you'll sign it, they'll take it. But if you won't, usually that's a pushback provision that nobody fights about. That it's uncommon to have a personal guarantee as part of a subcontract. So, and do realize for this reason and for all the other things we're going to go over, the first draft that comes over as a subcontract is meant to be negotiated, right? It's part of the process. And I think what's happened over time is that because people didn't negotiate it, they've got more and more and more one-sided. So, and when I say negotiate, that doesn't mean just crossing it off and saying I'm not going to sign it. That's like, okay, and I'm going to give you some language throughout this webinar of, okay, I'm going to cross this off, but here are some other options where we can meet in the middle. And because that's what we want to see. We just don't want to cross things off, right? And then they think you're, oh, well, you're not willing to work with us at all. And so if we meet in the middle and we're reasonable about it, there's really not much they can say. And if they're not willing to be reasonable, then you probably don't want to work for them. Right? So if we can point out why it's unreasonable and a reasonable meet in the middle in a negotiation, that's a reasonable thing, and that's not an uncommon thing to happen when signing a subcontract. So incorporation. So if you are a company, an LLC, an Inc., or any of that, you've been filed with Secretary of State, you have created an entity, right? And an entity protects you, the individual. So like you're an owner of a business, you have an entity, and you do business in that entity's name. As long as you're not signing personal guarantees, if anything ever happens, the business would get sued, not you personally, right? You're not personally guaranteeing your work. Now, don't get me wrong, like some material suppliers and credit cards, even if you have a company account, are going to require a personal guarantee, which means, you know, if it goes south and your company goes south, you personally could still be on the hook. So when we sign a personal guarantee, we're setting aside our corporate protection that is given to us by our entity and agreeing to be personally liable. So if that happens, you've signed a personal guarantee, they can look to the company or they can look to you individually. It doesn't matter which way goes first. They can look to you individually first or both at the same time. Basically, your personal assets come up to make sure you complete your work and or pay your guys for a project. So don't sign a personal guarantee on a subcontract. Just cross it out. So why you should incorporate, I kind of went over that. It protects your individual assets. You know, there are a lot of standard protections in Texas. Like Texas is one of the best states to live in if you're a debtor because they can't get your homestead, you can't garnish your wages. In other states, those protections aren't available, but Texas has a lot of protections. But to even protect yourself more, you can, you know, incorporate an entity and then your personal assets are protected, right? As part of that, though, you have to treat the corporate entity as its own thing, right? You can't use it as for personal expenses. You got to treat it as basically as a company. It's not just, you know, for you personally. It's for the company matters. You get a salary, but everything else is, you know, run for the company. Okay, so Kelly from Electrical Subcontractor had signed a subcontract with a personal guarantee. She finished her job, but there was a liquidated damages clause, so she didn't get paid. She was owed like $5,000, but the liquidated damages clause, she actually ended up owing the general contractor $5,000 because it was $10,000 penalty. And she's like, whatever. She didn't do anything with it. And apparently she got sued. And because she had a personal guarantee, her company got sued, and she got sued. And she didn't answer it, so they got a default judgment. And one day she was at the grocery store, and her debit card wouldn't work because her bank account had been garnished because there was a judgment against her personally for her failure to perform under the terms of that contract, and she had signed a personal guarantee for it. So if we do these things, it can hit home. You know, like going grocery shopping on your personal account. If you sign a personal guarantee and there's a judgment taken against you, they can get your personal bank account. So bonds are one way of personal guaranteeing, and then a personal guarantee flat out in the subcontract is another way to do that. So if you're going to do that, just know the risk going in. That's what my job is. I tell you what the risks are, and as a business owner, you can decide which ones you want to take and which ones you don't. So personal guarantees and bonds. Another issue that comes up a lot is prior work. And what do I mean by that? So like the work done before you. Can you be responsible for the work done before you? So like if you're the sheetrock guy, are you responsible for defects in the framing? Next slide, Chelsea. So in most subcontracts, yes, you would be. So what most subcontracts say is that before you start work, you have to go thoroughly inspect and point out in writing anything that's wrong and make sure it's fixed before you get started. And if you don't, that defect, whatever was there, if the walls were crooked or whatever, it now becomes your defect. So, and this is how everybody on a project gets sued, right? Because it builds one on top of the other. If it's, you know, all the way from the foundation guy to the roofing guy on a project can be sued because of this provision, because they accepted the defects before them. So there's some language that to look for and how to modify it. And there's some examples in your handout. What I like to do is, yes, I'm going to inspect, I'm going to look. If I see anything, I'll point it out, but I don't become responsible for the work that's done before me, right? If we'll go to the next slide, Chelsea. So yes, I'm going to go look. I'll point it out if I happen to see it, but if I miss it, I'm not responsible. It doesn't become my defect. We all have to work together on a project. I get it, but a sub can't take all the risk of the defects of the guy before him. That's just not right. And I'm not saying they'll stop you from still getting sued, but it'd be a great thing to say, hey, you sued me, but I said I wasn't responsible if I missed something. It'd be a much easier way out. So first off, know that these provisions are in there and what they actually mean, right? So if things are messed up when you get to the job site, make sure, point it out in writing and make sure they fix it. Or, if they don't, point it out again and again in writing to let them know that this is an issue. But try to change it in your contract. Like if you miss it, you're not responsible for fixing it. All right, payment terms. Okay, so the first thing when you get a subcontract, look and see when the pay applications are due, what has to be submitted with the pay application, and who it has to be submitted to, right? Because we know if we miss that deadline for the pay application, you're not getting paid until the month after that. So before we even sign the contract, let's find where that's at. Who are we sending it to? What's required? Do I need lien waivers? Do I need proof of insurance? Let's get that all squared away, because a lot of the times we fall behind on payments because we don't know that up front, right? We haven't looked into, because everyone has something different. And especially the first time you're working with somebody new, you need to know exactly what they're going to want on their pay app. I would even, try to submit it a little bit early, just to make sure if there's something that gets kicked back, to have time to fix it. So the technicalities of the pay apps and all of that in the contract, look and see what that is, and know that, they might use a platform or something like that. So know what that is. And if you don't have that platform, then you're going to have to pay to get it. You might want to look into the cost of that. So, and it would be nice if they would all be on one uniform thing, but everybody wants to use a different one. So make sure we look at that before we sign the subcontract and know what all that is, what the details on that are. But there are two main contingent payment terms. So in Texas, if it says paid if paid, generally these are not enforceable, because it's if. So it's like if you don't ever get paid, then if they don't ever get paid, then you don't ever get paid. So if it says if, it's generally not enforceable. But next clause, a pay when paid clause is enforceable. And what does that mean? That means that even if you did the best job ever and you submitted your pay up exactly on time, exactly the way it was supposed to be, that you might not get paid on time because you're waiting for the owner to pay the general contractor. That has to happen before you're entitled to payment. And so it's really puts your timeline of payments completely out of your control, right? And so we need to be aware, if we sign a contract with a pay when paid clause that we don't negotiate, the safest way to make sure that we're covered is to have enough cash to cover the whole entire project without getting paid. Because you don't know if there's something going on between the owner and the general that may lead to non-payment, but you're now taking that risk when you sign a pay when paid clause. So next slide. There's some language in your handout and some more at Subcontractor Institute. Let's negotiate the pay when paid clause, right? Okay, and so when I start talking about negotiate, what are the options? We're not just going to cross it off. We're going to say, okay, general contractor, if you submit my pay app and you're not paid by the owner within 30 days, and it's not my fault, like it's not my bad work that's stopping you from getting paid, you'll pay me 50% of what I'm owed. Or you'll pay me to file a lien. Or you'll pay me 100%. Something that's in the middle that we can negotiate, so not all the risk of non-payment falls back on you, the subcontractor. Just because you know nothing about the owner and you didn't decide to extend them, you're relying on the general contractor somewhat that he found somebody that's creditworthy, right? So this is one of the provisions. If you're going to negotiate, you would negotiate this. Texas, you can go to the next one. Texas law does provide a way out in theory. Okay, so there's a statute that says if after 45 days the general contractor hasn't been paid, and you, like the painter, it wasn't because of bad painting work, it wasn't your work that was causing the GC not to get paid, you can send a letter saying, hey, general contractor, I don't want this pay when paid clause enforced against me any longer, and demand payment. And if they don't, then they're breaking the law, and then you can sue them, which doesn't get your payment any faster, but could, accumulate interest later on. And I say that it's supposed to work. Sometimes it does, sometimes it doesn't, but under the law, it is supposed to be a way around the pay when paid clause when it's not your defective work that is causing the holdup on payment. So if you have more questions on that, I have the letter for free at Subcontractor Institute in the chapter that deals with pay when paid clauses, if you want to see what that letter looks like, or a draft of it. All right, delay damages. What are delay damages? Delay damages, also known as liquidated damages, are a per day charge when you don't finish on time. When I say finish on time, means when you don't finish by the schedule that's in the subcontract that you agreed to. So that's why we have to make sure when we're signing these contracts that our schedule is really something we can complete in the time frame that it says that we can. So it's based on your schedule. Know that going in. Don't sign a contract that has a schedule that's already behind or that you won't be able to complete in time, because even if they tell you they'll fix it later, because that's whatever's attached to that contract is your schedule, is what liquidated damages and delay damages will be based on. Another issue that I've seen happen in with delay damages is that even if it's not in your subcontract, delay damages could be in the prime contract. And that matters because in most subcontracts, the prime contract is incorporated. So I know I think I talked about this in the last webinar. The prime contract being incorporated in the subcontract, you either need to get a copy of the prime contract when you sign the subcontract, or have them take that provision out. Because if even if your contract doesn't have delay damages, the prime contract might. So make sure we look there for that clause as well if we've signed a contract that incorporates the prime contract. So a better version of delay damages, here's an example here. And what this provision does is base liquidated damages only if the general contractor actually has to pay the owner liquidated damages, because a lot of the times, even if you didn't finish on time and technically they're entitled to liquidated damages under the contract, they don't, and the GC doesn't end up paying those liquidated damages to the owner, which means it didn't cost them anything that you didn't finish on time. So I think that's a fair negotiation of a liquidated damage clause, is that I'm only assessed delay damages to the extent that you are. Like if the owner actually charges you delay damages, then I will actually pay them to you. If not, it could just be, used to reduce the amount that you're owed, not because there was any actual damages incurred by the general contractor. Another thing for delay damages I like to throw in this at this point, if the general contractor or owner does something that causes you more money, like if you're called out several times and you mobilize your guys and you get them out there and they're not ready for you, and that keeps happening, you're not entitled to extra money for that. Those provisions in the contract don't let you recover your extra mobilization costs, even if they told you to be out there. So if that's something that's important to you, let me know and we can find it and we can negotiate it. But the standard way that these things written, even if it's on purpose and they call you out there and it's not your fault, you're not entitled to be paid for those extra charges. So we can find these provisions and fix them and say, if it is their fault and they shouldn't have called you out more than once, that they could be responsible for the damages. We could put a price in there. So if that's something that's important to you, then we can negotiate it. All right, termination and default. Okay, so there's a couple of things in here. The first one is termination for convenience clause. What does that mean? A termination for convenience clause means the general contractor could fire you for any reason, no reason at any point in time. Now, you as a subcontractor don't have that same right. So if you sign the contract, you are on the hook to do the work and you can't just terminate, right? So know that going in, and I have a story about this at the end, but I see this most likely at the front of the project before you even start. If they found somebody else to do your scope of work for cheaper, they'll just terminate you and hire somebody else, and there's really nothing you can do about it because that termination for convenience clause. When you're in default, what is a default? A default is failing to do any provision in the contract, right? And then the next slide has some detailed examples. Some of the biggest things that I see as default is you're not working as fast as the general contractor thinks you should. That's a default, from the smallest thing of not doing daily reports, not submitting your submittal in a timely manner. Those are all defaults. And technically, a notice of default doesn't have to be an official letter from an attorney. It can be an email, a text, or whatever from the general contractor. So when you get those things that's pointing out and saying, here's your work is deficient and here's why, you need to respond with, yeah, okay, and here's what I'm going to do to correct it, or no, I don't agree, and here's why. So that way we have a paper trail that when a defect was pointed out, you took actions to cure it, right? So the paper trail is most important, and do realize that all of those little things can be defaults. And then technically, when you're in default under your contract, the general contractor doesn't have to pay you. So all of those little things can be default. So know that it's very important to know all the provisions in the contract so you can follow them so that you're not in default. So once you're in default, what happens? Normally you have they'll do an official letter for a big default and give you 48 hours to cure. And if you don't cure, you can be terminated. So, and those, they can come from an email from the GC, they can come from an attorney when they're giving you the 48-hour notice. And not all contracts require 48 hours notice. Some is less, some is not at all. So it just depends. 48 hours is generally what I see, but don't be stuck on that time frame. It could be more, it could be less. So read the contract to find out what to do there. But then you got to fix it. And so if you get a notice of default, like I said, send back, here's what I'm due to fix it, or here's why I don't think that it's a default. Whatever it is, CYA, cover your ass, and let's put it in writing so that it comes up again. We have a paper trail to prove what actually happened. Okay, so the other thing is, if you get terminated, what happens then? And most people just think that you're going to walk away from any money that you're owed. Yes, but that's not all. Under these contracts, if you don't finish your scope of work or you're terminated and they hire somebody else to do your scope of work or finish it, and it costs them more than what they were going to pay you, then you're on the hook for the difference. So know that if you get terminated or if you walk the job, it's not just you walking away from any money that you're owed. You could be responsible for a lot more. So, let's have if you're going to get terminated or you want to walk a job, let's have a serious conversation of what that looks like. How far are you from being done? How much would it cost you to finish, as opposed to how much would it cost you to defend a lawsuit? So knowing all that when you're signing the contract is hugely important too, because you realize once you sign that contract or once you put that bid out there and it's accepted, you're on the hook to do the work and you can't just walk away. So knowing those risks is super important. So the next story is I had a wall covering contractor that had ordered $10,000 worth of this wall covering that was wanted as part of a remodel. And then she gets terminated before the contract starts. And this is especially material. She can't return it, but they enforce the termination for convenience clause. And now she just has to try to use that material somewhere else or eat the cost of it, because once you're terminated for convenience, you have no recourse on things like that. So, these are just some of the things that are in the contract. I know I kind of went over everything really kind of fast. Like I said, if you want a more deep dive into any specific topic that was covered here today, I do it at Subcontractor Institute. But I'm here if you have any other questions. You can ask questions now, or we can talk later. All the things.
Okay. We've got some questions here in the chat already for you today, Karalynn. Stuart asks, isn't a personal guarantee required when you sign a performance bond?
Yep.
Also, won't the surety require spouses of business owners to sign off as well?
Yes, absolutely. And so there's two different ways to personally guarantee a contract. One is to get a bond, or two is to sign a personal guarantee as part of the contract. But yeah, the bond companies have, yeah, you're letting them know where all your assets are too. And that's why, because if they have to pay out, they want to know how they're going to collect.
Awesome. And then Ioana wants to see if you could explain the account payable again.
Okay, so the pay when paid clause or the pay app stuff. I'll go with the pay when paid clause. So what that means is you, the subcontractor, are not entitled to get paid until the owner pays the general. And then the general, under by law, has 7 days to pay you the amounts that you're owed. But that payment from the owner to the general, you have no control over, right? You hope that it happens on time. Most of the time it happens pretty much on time. But if it doesn't, what does that mean for you? That means you could have to keep working, because if you didn't get paid, you don't have the right to not stop working and not be paid. You can still move forward and file lien and all that stuff, and I highly recommend that you do that, because a lot of the times it'll shake payment free for everybody else. But yeah, I've never seen in any other area of work or anything that where somebody basically submits their pay application and then has to wait for some independent thing to happen that they have absolute no control over. It's very harsh. I understand that there's risk involved in construction, but should the sub have to be responsible for all of it?
That's super helpful. Does anybody else have any questions for Karalynn? You can unmute yourself or send them in the chat.
Sorry, I keep asking questions. It's me, Joanna.
You're good.
So am I like by law allowed to make, like, on my contracts, for example, I highlight through DocuSign and I put like notes on the contract, just FYI, saying that I'm not responsible for stuff, or et cetera, et cetera. Am I allowed to do that? Will that count in court?
Absolutely. Here's the thing, is that if they accept it, right? So, yeah, you can absolutely negotiate and send it back. And if, they accept it, then those are the terms, right? So what I would do is, they signed it, you send it back with all of your changes, and you sign it and say, this is basically, it's my counter offer. And if you start working, then those are the terms we're under. If they come back and say, no, we're not going to accept this, then obviously then whatever we end up signing is what would control.
Okay. And then my last question is, am I able to like put on my own contract, send it to them like a negotiable, saying that if they don't pay, after that 7 days, like you said, that they will have late fees or late time?
Yeah, absolutely. I think actually technically under the law, they have, under the prompt payment statute, it's 1.5% per month. I don't know what that breaks down per day, but yes, absolutely. But once they're paid by the general contractor, and they have 7 days to pay you, and if they don't, then you can accrue interest. Absolutely.
Okay. Thank you so much.
No problems. And if you ever need a contract reviewed and you want to know what's in there, I do it on a flat fee. So 0 to 15 pages is $550, and then 15 to 30 pages is $1,050. And what I do is I just go through and I highlight and I said, this is what this means, and this is what this risk is. And then you can decide if you want to negotiate it or not, but at least you understand what you're signing.
Okay. Thank you so much. I appreciate it.
And also, if anybody, go ahead.
I was just going to ask if anyone else has any questions for you.
Hi, I'm Maritza from Astro Construction, and I'm actually all the way over here in Kentucky. So so thank you so much for all this very, very, very useful information and helpful. I did kind of come in late because Julie gave me the link last week, so I did see the first session, but I feel like I'm kind of a little bit coming in at the end. Is all this like recorded or like, because I know it's this 4 parts. Okay.
Yeah, so we've recorded this today, and I'll be sending out a copy of the presentation in addition to the recording when we do have it uploaded, and the handout should be attached in the email that went out this morning as well.
Yes, I have the handout. I just know that there was like probably a few more sessions before this one.
I think there's one more, and I know we did record it, Chelsea. I'm sure we can send it out.
Yeah, I can, if you would send your email in the chat, I can document it and I'll make sure that I get the previous session to you as well.
Okay, yes, thank you so much. And I am on the Subcontractor Institute right now. You said we could sign up for free and then get like a whole bunch of like the course mastering.
Yeah, walk her through that. Let me see, I'll pull it up.
Yep, the course and all of the documentation and the free resources is all free access.
Okay.
As well as a pretty thorough breakdown of the lien laws in all 50 states.
So you click on, when you go there, you click on subcontractor education and it'll pop up the course, and it's zero. You gotta register, but it's zero cost. And then it has all of the documents in there and everything else.
Okay, yes, I see this now. Okay, awesome. Okay, thank you so much.
Laws of your state, just click on that and it'll pull up all the rules for all 50 states, lien laws, all the things.
Okay, thank you so much. Thank you all.
Mm-hmm.
Do we have any other questions for Karalynn today before we wrap this up?
Hey, Chelsea, did you put your email in the chat? So if they wanted to sign up for a consultation, they just email you and we'll get that set up.
Awesome, I'll do that right now. I've just dropped my email in the chat, everyone. And so if you're interested in setting up a consultation with Karalynn, talking about any issues that you may see in your contract or whatever else you may need help with, shoot me an email with your best contact number and what you'd like to talk about, and we can get you set up with a consultation. And definitely we will be reaching out after this when we do have this recording uploaded to make sure that you guys have access to it.